in the economic structure itself, because we are not caring about the persons who are putting efforts. We are not caring about the justice that is to be administered through the distribution of material resource of production, or even sharing of the benefits and profits. See, the type of development that took place in other parts of the country, that's also something to be taken into account. Without the construction of big dams, the drought hit districts of Bijapur or Gangavati, Koppal, or say Raichur and various other places would have would have continued only as such dry places. But once there were dams, each and every inch of those districts have been used. For example, Belgaum is the big beneficiary of a number of dams, and there are certain risks also during the time of flood. See, the development that took place in a say Kaveri belt, or in a Krishna belt, that's something enormous development. There is a big change the whole scene itself, because there is a greenery, there is a scope for production of food grains, sugarcane, and varieties of crops. This is how the infrastructural facilities like dams contribute to economic development. Jawaharlal Nehru considered that big dams are like temples. They are so important. They are actually providers of very live energy for the whole of the society, because agriculture is possible only with the very good supply of water. Then another resource that has a great role in the course of development is intellectual property. See, inventions which produce trade, patents, or various types of artistic, literary, and scientific works resulting in cooperatable works, or the goodwill that's established on the basis of trade, developing in the form of a trademark, or farmers' rights, farmers' competence, native ability of producing various types of breeds. See, these are all resources for development, and if there is a adequate law protecting these resources and encouraging those people who are involved in intellectual work, then of course there will be fillip to development. Thus, development is something to be done in a comprehensive manner. It is not one individual's work. It is a work that is to be done by the community as a whole. That's why it is a comprehensive process. See, this declaration of right to development has conceptualized the notion of development from that perspective. Then development has a far greater thing to contribute to the cause of social justice, because when there is a development, then there is a scope for resetting the social relations on a very sound basis, on a non-expectative plane so that people will not suffer because of illiteracy, ill health, and so many other things. That is the big advantage. This bottom-up approach is something crucial, or it is most important. But this is not to suggest that there is no such a role from the side of top-down model is also there. For example, big dams or so many other types of things that had contributed. Now, suppose a big dam culture is going to be substituted by rainwater harvesting or a revival of our traditional irrigation system like tanks or kattas, surangas, or various other types of things. Then there will be more scope for participation. People will enthusiastically participate in the developmental process, and they will be the persons are participating in the change process. See, when they are themselves instruments of a change, then the enthusiasm with which they work will be something that will be contributing to the cause of such a development, or it will lead to a greater success, because there will not be corruption, there will not be such kind of say defalcation of funds, etc. One big problem that is faced by the development sector is that in the name of a development, uh, see, so many corrupt activities are done, and mismanagement of a fund or scams or so many other things have occurred. See, here we have to uh, be quite careful, because we have to believe in the power of a rule of law. It is the rule of law system which can ensure that there will be avoidance of such a corrupt activities, or everything will be done in a transparent manner and in accordance with the law, and all will be the beneficiaries, and there will not be say siphoning of funds by some unscrupulous persons. See, uh, the idea of a sustainable development is also sometimes applied to deal with the situations of corruption. How exactly a development becomes a sustainable? When it's ecologically sustainable because of the conservation of resources, and ensuring of intergeneration equity, etc. There is also a need for ensuring that the development becomes sustainable, because people imbibe those principles of development as a part of their life, or as a very precious value with which they should live. Thus, development is a very important notion, and law has all such responsibilities of responding to development by enabling, facilitating, regulating, protecting, so that there will not be abuse, and there will be say sharing of advantages of that development, so that the benefit will not be cornered only by a few fortunate section of the society. See, we come across very eminent scholars like Gunnar Myrdal and various other thinkers who thought about development in Asian countries as something that ought to be done only through such a popular participation. Without popular participation, if through some imposition from the above, suppose policymakers are the sole persons who are to decide about the developmental policy, then there arises the question for whose benefit that this development take place, who participates in this development process, and what is the consequence, and is there any such a human right entitlement arising out of this development activity. Right to development is a human right because it is opening access to various human rights, then social and social, economic, and cultural rights can be realized, or even political and civil rights can also be realized through development. When political and civil rights were guaranteed through international convention, it was considered that to democratize, to ensure freedom from various types of exploitations, especially slavery and such things, and to ensure equal political rights, there shall be such principle. But without economic development, the political development does not become quite successful. The idea of a triple justice, there is a justice, social, economic, and political. That concept is a composite one, and although it is a composite, it is a economic justice which is triggering for attaining both economic justice and social justice and political justice. Economic justice is the begetter of the social justice and political justice. But insofar as the development is concerned, it stands above for this compartmentalization, like a social, economic, political, etc. Development is a comprehensive concept to include all the facets of human development. Human development, there is each individual should develop with all his competence, like skill, ability, education, health, and the discretion to decide about policies. That's the idea of development is more communitarian, or it is something to be done through collective exercise rather than an individual act. Although individual might be focus of attention insofar as a developmental process is concerned, because development is basically a process which brings a change. Thus, in the whole discourse relating to law and social transformation, these economic legislations which are in the form of investments are actually contributing towards a better economic position. With this, let me conclude. Let me thank the organizers. Yes, I took almost 50 or 55 minutes for my presentation. Thank you for your patient listening. Let me wish all the best to the whole of the program. Three institutions have been organizing this particular program for 5 days. Let it be a great success. Thank you very much.
Thank you, sir. Thank you. I truly appreciate you and your time to be spent in this occasion. Thank you for such an informative and interesting talk.
Thank you.
So finally, we come to the end part of the first session. I would like to welcome Dr. M. Somshekarappa, Principal, Oral College, Davanagere, to deliver vote of thanks. Over to you, sir.
Respected Speaker of the Day, my Guru, Dr. Ishur Bhatt sir, Principals of all post law colleges, directors and co-directors and participants. All is well that ends well. Together, all of you made this session a successful. I am obliged to express my sense of gratitude to you all. It gives me immense pleasure to render vote of thanks on behalf of 3 post-law colleges and participants. I thank wholeheartedly Professor Dr. Ishwar Bhatt, Vice Chancellor, Karnataka State Law University, Hubballi. His valuable speech has put us on a thinking mode relating to law and development. His thought was not only as a legal expert, but also as an economist of the country and as educationalist of the country, as an expert. I especially thank him for sparing his precious time for his online presence, has brought a unique environment in the minds of law teachers who are participated in this faculty development program. Thank you, sir.
Thank you very much. It's my pleasure.
Yes. I extend my thanks to Post Law College Principal Dr. M.S. Sudha Devi, Saraswati Law College, Chitradurga, and Dr. G.R. Jagdish, Principal CPR National Law College, Shivmogga, who are cooperated for conducting of this faculty development program. I extend my thanks to co-directors and coordinators of post colleges, and I extend my thanks to all participants. Thank you, one and all. Thank you.
Thank you, sir. In few seconds, we will start the second program. The present initial for every. Thank you for your attention. Welcome to the second session of National Level Faculty Development Program. As the object of benefit academic Judicial Assistant Professor Saraswati Law College, Chitradurga, to deliver welcome speech. Over to you, sir.
Srimati M.S. Sudha, dignitary and dear participants. Good evening to one and all. As we all know that Law College, R College, Davanagere and Shivmogga, Karnataka jointly organized national level 5-day faculty development program on law and development. Have our esteemed speaker, Professor G.R. Jagdish Sir, Principal, CPR National College of Law, Shivmogga, former Vice Chancellor and former Dean, Faculty of Law, Karnataka State Law University, Hubballi, to speak on the topic Constitutional Framework, Gender Justice and So, on behalf of Saraswati Law College, Chitradurga, our participant, sir. I also welcome Principal of Davanagere College, Ms. Sudha Devi Madam, to this session. I welcome faculty members of all the 3 law colleges and participants to this session. Thank you one and all.
Thank you, sir. Now I request Dr. Karyana K.S. Assistant Professor, Saraswati Law College, Chitradurga, to give an introduction of our distinguished speaker of the second session. Over to you, sir.
Good afternoon to one and all the dignitaries, directors, co-directors, coordinators, and participants of this program. I myself, Dr. Karyana K.S., Assistant Professor, Saraswati Law College, Chitradurga. It's my immense pleasure to introduce today's second technical session distinguished speaker, Professor G.R. Jagadish. Professor G.R. Jagadish is presently working as principal at CBR National College of Law, Shivmogga. He was born on 7th February 1963 at Channagiri, Davanagere district, Karnataka. Professor G.R. Jagadish completed his earlier education in Channagiri and pursued LLB degree from National College of Law, Shivmogga in 1986. Later, he obtained LLM degree from University of Mysore in 1988, specializing in constitutional law. Later, he awarded PhD degree from Kuvempu University, Shivmogga, Karnataka. Later, Professor Jagadish joined National College of Law, Shivmogga as assistant professor in 1988, and he was promoted as reader in the year 1997. He was also promoted as associate professor in the year 2002. Professor Jagadish was also worked as acting vice chancellor of Karnataka State Law University, Hubballi. He also worked as dean Faculty of Law for Kuvempu University and Karnataka State Law University. Professor has worked as chess, BOE, etc. Professor Jagadish also worked as chairman of experts committee to recommended unaided law college for grants, Government of Karnataka. He also drafted grant in aid code for 19 aided law colleges. He has published more than 50 articles in various national and international journals, and he has published. He was an elected member of Academic Council of Kuvempu University from the Readers Constituency. He was also the member of IPR cell of Kuvempu University. His area of specializations are constitutional law, administrative law, family law, etc. He was instrumental in commencing LLM distance education program in Kuvempu University. Professor has played vital role in the commencement of regular postgraduate studies in law program at National College of Law, Shivmogga. Thank you, one and all.
Thank you, sir. Now, the announcement. You will have an opportunity to submit text questions of distinguished in the typing your question into the question pan of the panel. You may send time during the at the end of the presentation. Without further, I would welcome second session to start. Over.
Hello. Am I audible?
Yes, sir. Yes, sir. Sir, you can continue, sir.
Thank you. Thank you for the nice words, Mr. Karyana. Now, after the Vice Chancellor's presentation on this very law and development, it's a great privilege being his student. We learned a lot from him, especially in the area of law and social change. Today, I am concerned with this very constitutional framework, and that being the case with respect to gender justice, and what is the development that took place for the last 70 years of working this constitution. So in this contextual background, now I would like to present this PPT as and based on that also yeah, based on this, we'll go for the very analysis what is required for this constitutional framework and how this very gender justice is made possible and the development that took place all these years. Either this may be from the legislative point of view or from the judicial interpretation of the provisions of the law, or it may be in connection with these executive measures for the very gender justice. So, regarding this very term, sex and the gender, that we have to draw a line of distinction. See, very particularly, this very term sex and gender being confused a lot by many. Sex is a personal aspect and a biological factor, whereas gender represents socio-economic, cultural, and psychological factors that make one class strong over the other. So this distinction we are supposed to know. They are not one and the same. Sex should not be synonymously used with this gender. With respect to this gender, that stands for characteristics of man and woman, which are socially determined rather than biologically identified. So, this is what the gender determines the social role, access to opportunities, entitlement to resource for men and women, and builds cultural implications upon them. So, in practice, the image of gender generates biases in favor of men and against women in relation to work, sharing benefits, enjoying of human rights, and following of tradition. So, this is what we are supposed to take note. So, gender justice as a matter of concept implies a comprehensive goal and scheme of protecting the class of subordinated gender from the exploitations and denials inflicted by the dominant gender. So often we can refer to this patriarchal family and matriarchal family like this. So this is in a private sphere. So in this context, it means that women must exercise full participation in decision making process in all walks of life and fully share opportunities with men in finding equitable and practical solutions to issues in the family and society. So we are concerned with both the private as well as public sphere. So gender bias, and is there a need of law in setting right this very bias? So as we are aware of that, historically, women were discriminated in all spheres with respect to the education, employment, property, and also in political life. So she was denied with respect to claiming her rights. So regarding housekeeping and childbearing, caring, and in the upkeep of family spirit and ethos, the woman's responsibility is practically exclusive. So maybe this may be a ground for drawing a line of distinction between some of the roles to be paid only by the respective male or the female. Now, with respect to this biological characteristics of the woman, so that is vigor of the woman race is to be protected because the future of the nation depends upon them. Now, this being the case, essential, the biological characters being essential for continuity of the mankind, often the factors that face male aggression. So this is what the situation, but still we are having such type of apprehension in the area of female feticide, or maybe the fear of cloning technology, or this very increase in the offences committed against the body of the woman, and maybe even sexual harassment as such. With respect to this gender justice, this very aspect is considered to be a part of social justice. So means elimination of the institutionalized dominance and oppression. See, who is dominating or who is subjected to this very oppression? So we are having such type of models of distributive sense, distributive models of power, rights, opportunity, and self-respect. So in this area, we would like to just check how this gender justice is made possible. So there is a need to focus on the issue of decision making, division of labor, culture for a social condition that enables the woman's equal participation. So maybe this sameness approach is required for both the female and male, or is there any need of recognition? That is the question here we are confronted with. Recognize the difference between male and female, but employ the appropriate strategy to deal the oppression and result from tyranny. Now, how to this very oppression has to be managed? That's what we are concerned here. So the everyday practice of well-intentioned liberal democracy we need. An attitude and all-round changes to upset the trials and travails of women can be engineered to some extent by legal system, as it has only best alternative apart from the education to influence the human behavior. So, in this background, we have to see what is the value that has been incorporated into the Constitution of India and the policy background for the development of gender justice. So, this very Constitution being the supreme law of the land, that inspires, control, compel the ordinary legal norms towards compliance with its enshrined values. So, as you are aware of that, Article 13, 1 and 2 are very clear under the Constitution that law which is inconsistent with the fundamental rights to the extent of inconsistency will be void. Similarly, Article 13, Clause 2 speaks about states shall not make any law contravening the fundamental rights. If the law made is contravening the fundamental rights, then that law could be declared as void. That's why there is such a consistency between the Constitution law of India and also the laws being enacted under the Constitution. So Constitution has explicit measures for attaining gender justice in view of this, and there is constitutionalism for empowering the women of India. This is what the assertion, this is what the claim. But we have to see how far these very legislative measures they are really implemented by the executive, or whether judiciary having any such attempt or endeavor being made from their side for the dignified life of the woman. So this idea of affirmative action for women's uplift during the last 70 years has to be taken into account, and in view of that we have to see whether this very feminist jurisprudential thoughts on gender justice got its oar in the Indian context. So this very legal status of woman is being largely influenced by what the position she is enjoying in the present day world. So in the patriarchy, so far we were, and even today also, the legal stance and the practices of prostitution are prone, or maybe sexual offences, or with respect to marriage and property and economic relations exhibited the maleness of law. So this very dominance in making of the law, that part we have to take into account. And maybe the division between the public and private sphere and allocation of the farmer to the men. That's what we are concerned with the national level decisions. And whatever the domestic sphere is what relegated to the woman. So here the woman was maybe invisible to the law in the past. Now, whether we could achieve anything in that respect, that we have to see. See, maybe in that sense, there are some approaches. For instance, for a life of dignity, devoid of power in public sphere as well as at home, she had to wait for unlocking the doors of public world through agitations and by entry into workplace or for the dawn of reforms. So she was relegated back to the domestic sphere or private sphere, and from that she has to come out in the public sphere. So some of the challenges from the patriarchy, she has to respond. So in that sense, the age of enlightenment also among the citizens brought to the center the concepts of rationality, individual choice, and equal rights and opportunity. So this has really paved the way for the improvement of the conditions and status of women. Now the question is whether she requires a special treatment or a similarity between the male and the female. So with respect to this, we have to take into account what the liberal feminist prefers. They prefer equality on the basis of similarity between sexes to special treatment. So this very similarity between the sexes, equality on the basis of similarity, they prefer equality on the basis of similarity between the sexes to special treatment on the basis of sexual differences. Why this is, in fact, under Article 15, Class 3, we made it possible that special provision could be made in favor of women and children, and Union Parliament or state legislature can take steps to treat her differently because the vigor of the race has to be protected. So this is what criticized because this equality would benefit women only if they acted like men. This is what assimilationist theory. What in fact in some of the theories that has been advocated that if you treat this woman on the basis of sexual differences, she will be the beneficiary at the exclusion of men. That is not we are expecting here. So maybe like should be treated alike and not the unlike like. So there is one more approach with respect to this very ameliorating the status of the woman that we say anti-subordination approach. So this is what beyond the arguments of equality, radical feminists challenge the structure of society itself and the law therein and deeply criticize the patriarchic culture and mores. So this is either the patriarchic or matriarchic. So that is what the structure of the society itself is not proper, and the law enacted therein is also not rational. That's the very thing advocated by radical feminists. They, for instance, law on rape, they regard by looking to the factors of woman consent and undermines the reality of male aggression. So when this very consent turned to be non-consent, that is one more issue that we are confronted in the recent past. So male aggression is there normally when he is in a domineering position. So there that factor has not been looked into. So this is what radical feminists would like to challenge the law itself. Regarding prostitution law on prostitution, see, by avoiding only commercialization of the service of sex workers, treat women as only sex objects. This is what radical objects to that. So we look from commercial angle. If somebody earns out of running the brothel house, that's what a commercial aspect is only taken into account. And woman in that sense was considered as a sex object and nothing more than that. And as a victim, what she is entitled, that is to be taken care. Continuing that, even the some of the aspects that being ignored in the porn area, say for example, abuse of women in pornography production industry. See, therein the woman was treated as object of bodily pleasure and incremental consequences of pornography and sexual crimes. So this is what the thing is that focuses only on protecting the pornography consumers from depraving and corruptive influences. They are least bothered with the victim of the prone. Victim here, only the person who is using according to the law. But the thing is that woman has been used as the object therein, maybe for bodily pleasure or for incremental consequences of pornography and sexual crimes. So this aspect to be given due importance, That's what to be given in consideration. Maybe reconstructing the sexual equality is the need of the day. The concept of sexuality by recognizing the woman's difference from men, our identity and specificity. So, for example, maternity benefit law accepts woman's difference as a basis for special treatment. See, now that has been enhanced in the Indian context from 4 months or 4.5 months to 6 months, and she could go for 1 year leave with pay. This is a beautiful development in the post millennium tenure. At the same time, paternity burden law to take care of his child and child's mother. So, taking the maintenance of the child and child's mother, this is what the burden imposed on the father. So, this is paternity burden law. And in this context, law has been modified, our service rules have been modified that father can go on leave for some 15 days earlier. Now it has been enhanced to 30 days or 1 month. So he has to take care of his wife and mother of his child. So one thing we must take note in the family relationship that there is an interdependency and that is indispensable. So with respect to caring, relation consciousness and distinct moral vision, women are considered to be more caring, more relation conscious, and have distinct moral vision. With respect to this essential connectedness with the children and family members should be properly respected, and law should support women valued relationship. See, some of the things we are concerned here is mandatory pregnancy and female infanticide in this family relationship is going against the woman intimate choices. No, after marriage as such, she is under the obligation to bear the child. This is what the traditional belief in the Indian context. Maybe in that sense also the female feticide. This is unfortunate contribution of the patriarchal domination in the present society also. So maybe some of the forms of this gender injustice we have to take into account. See, this gender injustice is primarily located, as I mentioned earlier itself, in the domination and oppression. Now, these are the two areas where this domination can be seen. For instance, domination is an institutional condition that prevents people from participating and determining their actions or conditions of actions. Whereas oppression abstracts communicative and learning abilities. See, there are some 5 phases of oppression. One is exploitation, second is marginalization and powerlessness and cultural imperialism, and lastly violence. Just have an introspection. See, woman is subjected to this type of oppression. Maybe with respect to oppression, see, regarding this oppression that occurs through a steady process of transfer of the result of labor of one social group to benefit the another. So often it has been charted that getting married and running a family is what at the lesser cost than living on alone. So marriage is a class relation in which women's labor benefit without comparable remuneration. This is one area of exploitation. This is what I'm speaking of feministic point of view. See, in fact, we also tried to have a model bill for the payment of homemakers remuneration bill 2021. This could be what you made use by the faculty members or my colleagues in a mock parliament computation to be held for the last students. See, with respect to sex affective protection, where the woman transfer energies to men and children with emotional care and provide men with sexual satisfaction, and as a group receive relatively little of either. So this is an unfortunate situation this when she is giving such a care. She is also transferring the energy, the servers and the servers enhances the status and comforts of the served, keeping themselves structurally subordinate. Now, often it is the demand of the younger children, especially for everything till they attain majority or even after the 18 or 19, like that. The children will be expecting mother will serve, mother will do whatever they require. So there is a transfer of energy. So by transfer of energy, the servers enhances the status and comforts of the server. So here it is not the enhancing of the status of the children, but comforts of the served will be enhanced. So in a comfort zone, children prefer to get the continuation of the service by the mother. Now, keeping themselves structurally subordinate. So this is what some household work she is doing. So that will keep her in a subordinate position, as I feel. And dispensing this exploitation, how it could be. Injustice of exploitation cannot be eliminated by redistribution of the goods as structural relations remains unaltered. The father, mother, or wife, husband, or children, parents, like that. The structural relations continue to be the same. This exploitation cannot be so easily eliminated just because the goods have been redistributed. That we have to consider. Here, we have to bring about justice where there is exploitation by requiring reorganization of the institution and practices of decision making, alteration of the division of labor, and similar measures of institutional structure and cultural change. See, be the change in you what Mahatma Gandhi has come out with. This has to be applied in the family relationship. See, with respect to the reorganization of the family institution in the private sphere, or with respect to the practices of decision making therein. Now, how you accommodate the decision taken by the father or decision taken by the mother or one of the elder brother, like that, or elder sister, or how you could alter the division of division of labor. Say, for instance, who has to cook? Normally, the mother will take care of the cooking. So, is there any assistance by the children? Very rarely we come across. Now, as if it is the duty on the part of the mother, she has to do that. That is the very attitude by everybody. So, or else husband is expecting the wife should do. If she is not, if she is also an employee, also there is an expectation. So, maybe with respect to institutional change or cultural change, so we have to make it possible. So, in that sense, there can be such type of another area, marginalization. So, this is a dangerous form of oppression. So, here, particular category of people are expelled from useful participation in the social life, and thus they are subjected to severe material deprivation. So maybe in this sense, dependencies arising out of such situation tends to suspend their basic right to privacy, respect, and individual choice. Now, if the particular woman or a girl is having such a dependency, for instance, in the absence of decision making, in the absence of economic stability, or in the absence of the property right, maybe she is dependent. Now, if this prolonged dependency is continued, this will be a basic human condition that corners them to sense of uselessness, boredom, lack of self-respect of equal citizenship. So this can be considered as marginalized category. Now you can just assess some of the persons who are doing the stereotype of work. For instance, people doing labor in garment factory. Say from this is almost like a 12 plus 2 hours, going 1 hour, doing work for 12 hours and coming back 1 more hour. 14 hours duty their labor they are exerting. So this is like that. What is the fun in having life? They feel the sense of uselessness or boredom, and they lack the self-respect. So maybe in that sense, they consider themselves there are all are equal and some are more equal. So one who is not there in the some are more equal, then he is marginalized. The woman in many sectors being marginalized. So we are having good number of welfare schemes by the government also. See, that shows the dependency here. Say whatever the government is doing, whatever giving pukkat or free of cost, everybody would like to have that taste. Say maybe many bhagyas the government at the state level or the union level they are extending, and some free facility being given. So this is what somewhat dangerous form of oppression, especially in the marginalization sector. Now, what is the remedy we have to? See, we have to restructure this productive activity to address the right of participation outside the wage system. For instance, we are having MNRG, Mahatma Gandhi National Rural Employment Guarantee. That's what guarantee is done, and many persons' name being there, and it did not do any work there, and the technology has been made used to work, and somehow the encash was made by the beneficiaries. So this is again the dependency here, and a prolonged dependency maybe. See, it may be even with respect to assistance given in the case of unemployment. So you would like to continue as unemployed. So that very assistance given for the unemployment. Otherwise, the government or the state has to create such type of opportunity for work, opportunity for employment. That is the thing they have to do. See, another area of this very oppression is powerlessness. In other words, the lack of authority, status, and sense of self. Maybe this is what you cannot find with certain people. What the professional tends to have. Now, professionals claim some different privilege and symbolizes the very status therein, possession of specialized knowledge, ability to decide or alter the legal position of others, and respectability attached to the position. Take the example of an advocate, say, or a doctor, or an engineer, or a teacher. The entire society listen to them. They act according to what the professional speaks, professional says. So they possess specialized knowledge. See, look at this ability to decide or alter the legal position of others. This is the beauty part here. So, and the respectability they claim, this may be absent with respect to the person who is not having authority, who is not having status and sense of self-respect. So, this powerlessness is one more problem we are finding with the woman. So, in this context, the dynamism and self confidence brimming in the professionals stand contrast to the position of non professionals. So, women largely belong to non professional class. See, look at, we are having personal secretaries, we are having this very garment factory workers, we are having data entry operators, and like that, their position is always relegated. You may be surprised, the vice president of the United States of America, she is the first lady in the history of American independence. After 230 to 40 years, more than 2 centuries, for the first time, women occupied the position of the vice president. No, in other words, I am telling that even after 240 and add years, a woman cannot, or woman was not allowed to occupy the pivotal position of the President of United States of America. Fortunate we are. We were having a woman president. We were having a woman prime minister also in India. This oppression of powerlessness is basic to industrial societies, wherein the structural changes for amelioration is the need of the hour. We have to change this very structure of the industrial society, And simply, even I used to say the software engineers nowadays almost said to be the modern time slavers, slaves like that for the corporate sector. A minimum of 14 hours. The scale or pay is high, no doubt. But the work they were extracted, the corporate sector is extracting almost 1.5 or double the work what a common man is doing for 8 hours. So this is what required to be looked into. And one more area is cultural imperialism. See, this involves the universalization of dominion's group or dominion group's experience and culture and its establishment as the norm. Maybe here the views, values, and cultural products of the dominant group gain a greater currency because of the projection of their experience as representative of humanity as such. See, this is where even today I may be addressing on how this constitutional provisions or framework is permitting for gender justice and how we have worked out this constitution for the last 7 decades. Still, I may have an hangover. I'll doing theoretically, I'm saying all this, but the male domination in the attitude or the views or the values, the person listening or the person addressing on the topic may be both having such a view. No, whatever may be, men is men. See, always that may be the attitude. So, values therein, the cultural products of the dominant groom gain a greater currency because of the projection of their experiences as representative of humanity as such. So, this culturally dominated or marked out by stereotypes and at the same time rendered invisible. So unknowingly, this is considered to be part of the society. It is inevitable, indispensable. We have continued to live and no alternative for that. This may be again another view. So oppressed groups' interpretation of social life finds here little space for expression, whereas the dominant culture imposes its experience and view upon the dominated, the ruler and the ruled like that. This may be in the public sphere, in the private sphere again, the patriarchal and the matriarchal we are coming across. And the last one is the violence. This is one form of oppression against women. See, deep-seated disrespect against women. No, in the recent past, now the political lobby or the political culture is that whenever men MLA, men MP dies, normally the seat is allotted to the widow of that deceased MLA or MP. This is what normally the people from other side will say what that woman can do. See, you might have come across a recent WhatsApp viral that Mysore MP was telling what that Mandya MP can do. She is a lady. If any thing you want to get it done for Mandya, I will do it. This is what that Mysore MP claims as such. So this is what a disrespect against woman. Maybe in that sense, this is what deep-seated. A sense of superiority on the part of the males and helplessness of women because of the factors of oppression. So claiming that even the woman also feels whenever the new girl child is taking birth in some family, oh, the woman herself is claiming, oh girl, yeah. This is what even the woman is having such type of what we say phobia. So they have been responsible for the repeated act of violence against women. So viewing such type of incidents of violence against women as symptoms of social injustice, where red lies this remedy, structural reforms by requiring redistribution of resources, positions, reforms of criminal law, and alteration of cultural images by abandoning stereotypes and aversions of everyday life. So some of the common forms of violence against Indian women also could be traced in this sense. I already mentioned This abortion or female feticide and dowry there are mental and physical torture, sexual trafficking, and public humiliation are some of the common forms of violences. So maybe throughout her life cycle, the woman is subjected to such type of discrimination we say. For example, at the pre-birth stage, sex-selective abortions can be traced and battered during pregnancy and birth outcomes. Maybe this is what in the traditional Indian families we are coming across. During infancy, that female infanticide, physical, sexual, and psychological abuse of the girl child is going on even today. And girlhood status as such is facing the problem of child marriage, and maybe especially among Muslims, female genital mutilation is found to be, and physical and sexual as well as psychological abuse is made against the girl, incest, child prostitution, and pornography during adolescent stage. These are some of the problems encountered, and maybe courtship violence also there. So this very adulthood of the girl or woman was said she is facing economically coerced sex. Say, for example, sugar daddies, we say often for return of some fees. Maybe that is a situation. Sexual abuse in the workplace and incest. More crimes are committed within four walls. In other words, that's what I would like to quote with respect to incest, or it may be the rape or sexual harassment, forced prostitution. Man is selling, in fact, his wife to a brothel house, maybe for making money therein, and pornography, trafficking in women, then partnering violence. See what we say in the recent past as such, maybe honey trap as such. So marital rape also considered to be a type of offense. Any sexual offense without sex without the consent as such is what even by the husband is considered to be rape. Dowry abuse and murders, partner homicide, psychological abuses therein, abuse of women with disabilities, and forced pregnancy. Regarding elderly women, they are forced to suicide or homicide of widows for economic reasons, and there are such type of sexual, physical, and psychological abuses. Now, this is what violence against women by World Health Organization has come out with. Say a broad category of oppression and dominations we have to take into account. The social practice of neglect in women's education. But in the recent past, the ratio has come up. Slowly it's growing, and in fact, the Karnataka government also extended the exemption of tuition fees for the girl child till she does that very graduation. So this is a wonderful development in the Indian context or even Karnataka as such. And non-involvement of women in economic process or lucrative employment. Now, I already mentioned secretarial position, PA like that, or garment factory worker. So this is what they are relegated because of non-skill from the perspective of the profession. See, they are more non-skilled workers as such, and anybody can do that. That's the thing the male-dominated society considers. See, woman in the economic process is very rarely considered. Now, in fact, even positivist has come out with the idea she is better fitted for domestic economy like that, and not for the economy with of the state, economy of the government or economy of the union like that. So even with respect to occupying the top position, lucrative employment or managerial positions, very few you can find. Maybe with respect to ICICI Bank, earlier Kochur was there, Biocon, that lady Majumdar is heading. Very few we quote from the Indian context. See, this is what they have been denied some participation in the economic decision making or economic process with respect to either corporate sector or it may be public sector, or she may be dispensed from holding lucrative employment or managerial position. This is a bad category of oppression we are finding. Lack of protection in the workplace also. Maybe female feticide. Now if you go for ratio known to all, maybe for every 1,000 men you can find 930. This is the average ratio of the woman. Maybe in that sense, often it is claimed demand and supplies are normally men of more age will be marrying a girl of lesser age. So there will be, depending upon the demand, supply will be there and ratio is fine. This is the claim often made by the patriarchal family. So this child marriage as such is practiced even today after 70 years of working this great constitution. This is an unfortunate situation. Only by 2006 we could make a law prohibiting the child marriage. Otherwise, earlier, according to the provisions of law, even the child marriage was considered to be voidable at the option of the other party and maximum punishment of 15 days. That was the situation. But now, after 2006, the child marriage is considered to be void marriage. So in Karnataka, at least we are having that provision. So continued to be practices the harassment for dowry. And now people are very shrewd. They alternatively go for the employed woman. See, employed husband and employed wife. So this is the configuration in the marital relationship we are coming across. And both are earning so that the life can be made comfortable. And instead of demanding for dowry, this is what continuous income till they attain the age of superannuation. But the problem is the consequence, the dowry death here. See, when this dowry death as such occurs because of the demand, or it may be at the instance of the husband and his relatives, or suo moto on her own committing the suicide. So more number of molestations are taking place and rape is committed in the public sphere as such. And this is what super added by male bias in family law and criminal law. So one more area is poverty and natural calamities have made deep dent into the conditions of women's human dignity. See this whatever tsunami that is taking place or now COVID consequence as such that relegated the position of woman into that very poverty, and these natural calamities often creates a type of deep dent to the very status of the woman's human dignity. See, maybe a lot number of examples could be quoted in this respect. And you can find, as I mentioned earlier, sale of his wife and sale of girl child and practice of child prostitution are within this frequent social experience. So this is continued to be there. And how to counter this very gender injustice? This is the problem we are facing. See, either through this ethical law and politics, the dominance and power imbalance can be rectified. Now, what is this ethical law? The morality of the society has to be incorporated into the instrument of law so that we can bring some change. That's how the law could make some change in the very aspect of working the society, a structure of the society, and also the politics. See, this very imbalance, power imbalance can be rectified. But unfortunate situation with respect to the political parties, they themselves are not doing with this very democracy inside the political parties, and also with respect to allotment or giving of seats reserved in general for all. See, normally allotment of the seats is made with respect to the men only, and very rarely in the absence of on the demise of the husband MLA MP, I mentioned the widow is given the seat. So internal democracy itself is not there. So political restructuring is required in that sense. See, discarding the public-private dichotomy in order to empower women in both the spheres becomes essential. So this is a big task we are hunted with. So unless the attitude is changed either in the private sphere, we may be very good in the public sphere. The moment we go back our home, we start dictating the terms. Why you did not do? Why you are not doing this? So this may be a situation. So this dichotomy, whatever you are inside, you also be the same outside. This is what the scenario we are expecting. This dichotomy between public and private has to be discarded in order to empower the woman in both the spheres. So raising woman question and arousing woman consciousness are to be the initial strategies. What is the strategy? Now we have to create awareness as such. We have to question why this shall not be like that. So there is a necessity of comprehensive approach for this gender equality and anti-subordination and fair relationship. So how to empower this woman? Basically, infusing competence into the category that does not presently possess it, and welfare scheme for education, employment, self-help, collective activities, and better legal environment for women, equip them with needed power. So this is what the government in its policy aspect has to take care. Education, employment, self-help, collective activities, and better legal environment. So this may improve the status of the woman. And empower, I mean here, this very woman's power of self-organization is promoted and reinforced, and they develop the capacity of self-reliance, outcrossing the relationship of subordination on account of gender, social and economic status, and the role in the family and society. So here, human development, if not engendered, is fatally endangered. For instance, if you take Goa, state of Goa as an example, the economic stability is also given by means of giving property right long back. There are very less number of dowry harassment or dowry death or no, not at all any dowry case pending in the court of law. So economic stability is one such thing required for the improvement of the status of the woman. This has to be even from the socialistic perspective. So, and also societal perspective. No, I don't think any historical perspective analysis is required. Maybe what happened in the Vedic period and how this very male dominance in the very name of protecting the woman has come out. And there was a type of sati practice, and that being objected by Rajaram Mohan Rai, and also William Bentinck helped him to make a regulation long back by 1829. See, particularly in the 12th century Karnataka Renaissance, there were such type of movements that was to be laudable as such for restoring the position of dignity of the woman. So this is what particularly what in fact Professor Ishwar Bhatt who inaugurated and came with such type of beautiful analysis of economic development and social development. He made a good analysis with respect to this, and he identified these very radical movements in the non-Brahminical sector, especially in the 12th century of southern India. Lord Basavanna did a laudable effort to restore the position of dignity to women as such. Even in Vachana literature, that soul that hovers in men and women knows no sexual difference. See, what we say, soul in both the men and women is not having any sex at all, in other words. It has been clearly mentioned in the Vachana itself. Bhakti literature also advocate for reordering of the society on egalitarian lines. See, feeling of one's own sex that makes the opposite sex a taboo. So the feeling of that, I am the man, I can do whatever this or that. I can go back home by 11. I can come back next day. So this very feeling of one's own sex, that itself is creating a taboo on the opposite sex. In other words, you are not ready to respect the other. See, this co-education, in fact, really created a lot of respect in the other sex. Otherwise, there is such type of hangover that we are superior. So men are doing always mischief. Women are always this, that. This will be always what we say gossip. All the men and the women in the world are is living forms. This is what Kabir has come out in his analysis. So all men and women in the world are is living forms. Maybe referring to the God, he might have said, why call women bad from whom are born kings? This is what Guru Nanak has come out with. See, when man is mother of the future kings, future generation, see, why you call the woman as bad? See, this is also we considered in the temple entry case from Kerala. So woman considered to be bad between age 12 to 50. Below 12 and after 50, woman is good, and woman in between 12 and 50 only bad as such. So this in the medieval period also this increase in sati practices and female feticide took place, and there was a step of ban of involuntary sati during the time of Akbar and Jahangir. They put some efforts to ban this very involuntary sati. Voluntary sati, in other words, they allowed, they entertained. But involuntary sati, if someone forced the widow to get into the pyre of the husband, that is what prohibited by Akbar and Jahangir. And whereas if it is voluntary, they didn't do anything. Prohibition of child marriage and permission for widow remarriage or the steps in elevating the status of woman. See, even during the British regime, colonial times, such legislations were made for widows remarriage, as well as Sharda Act, earlier name given to the Child Marriage Restraint Act, later it was called to be. Now we gone to the extent of improvising the very legislative measure, and by 2006 we totally made this child marriage as a void marriage as such. With respect to this denial of property right, made these reforms a mockery. Earlier, she was said to hold the property during Vedic period because of the long gestation period of bringing up the children, especially among the human beings. This is the long gestation period, and denial of property right is what the mockery of all these reforms, we could say. Maybe in the colonial period, a lot of legislative measures have been taken up to abolish the practices of sati and female infanticide, and reforms took place also with respect to family law. And there was a step of Devadasi. Unfortunately, even to some extent, this very temple prostitution is continued to be, and dowry also continued to be in vogue without much legal attention. See, other forum, whatever gifts given, not even today being brought under the definition of dowry. Many legislations being enacted to improve the woman's dignified life that modified certain practices, maybe sati regulation, caste disabilities, widows remarriage, special marriage act. This is a one great step. The persons of Indian origin, irrespective of the religion they belong to, they can marry under the special marriage act. This is a great step taken during British rule by 1872 itself. And among the Rajput tribes, the female feticide was prohibited long back by 1870 itself. Age of consent was also incorporated by 1890. That maybe even under the this Guardian and Wards Act by 1890 it was there. Legal Practitioner Women's Act 1923 with respect to women as practitioner as such that being dealt with. Women's Right to Property Act was the first enactment in Karnataka, for holding the property to the limited extent. Limited estate right was conferred on the woman so long as she lives therein. So Muslim Women Law Shariat Application Act was enacted by 1937 and Dissolution of Muslim Marriage Act 1939 was there. So dawn of independence and the making of the constitution really ushered in new era of social justice and human rights. There is such a scheme of social justice that was incorporated into the national agenda. That is what a part of the Constitution of India. We could have such type of equality clause for prohibition, uh, not only prohibition upon making discrimination amid citizens on the grounds of sex, but states' power to make special provisions for women and children has also been provided for. Article 14, 15, 1 and 15 class 2, 3. This speaks about that, and 16 class 2 also mention about this equality class. So the why I mentioned this equality class is great when compared to other constitutions of the world, because this is unique as other constitutions are not having such type of parallel provisions. Now, in the Constitution, we could find, especially in the preamble, concept of social justice. See, justice, social, economic, and political we use there. So, social justice we advocated there. We are having constitutional provisions for no discrimination. We are having that equal protection clause. We are having affirmative action under Article 15, Class 3, 4, and also 16, Class 4A, 4, 4B, like that. And this very problem is with respect to the prohibition of immoral traffic and exploitation. Unfortunately, the immoral trafficking is not considered to be exploitation under Article 23. That we have to take into account. Now, human and equitable conditions for women at workplace, in access to civic facilities and in intrafamilial relations. So this we have to take into account, and we have to consider the judicial initiatives for developing the case law on women's rights, and also some of the constitutional amendments being made for the restoration of dignity of woman. So this Article 14, where state shall not deny to any person we use. Any person includes woman also. So woman is also entitled to equality before law and equal protection of the laws. So 15.1, 15.1, then 16 class 2, all these are in connection with no discrimination on the ground of sex as such in general matters, as well as in respect of employment or offices under the state. So these are the provisions laying the foundation for the legal equality of men and women in India. With respect to special provision under Article 15.3, 15 class 3, provision has been made to empower the union parliament or state legislature to make special provision for this very woman and children. Now, this in fact, I earlier said that the vigor of the woman race has to be protected because the future of the nation depends upon them. So this is in recognition of the fact that women in India have been under subjugation for centuries and require special protection as to empower them and make them effectively equal with men. So, in this context, you can find such type of reservation is made even in local self-governing bodies, municipalities, other bodies, cooperative societies, for instance, especially the recent amendment of accommodating minimum 2 women in the cooperative society and concession in tax for women entrepreneurs and reservation in employments as such, especially in Andhra Pradesh and in Karnataka, nearly 30% and above could be reserved for women whenever they are appointed as the teachers up to the secondary school living level. and educational institutions also where reservation is given to women. So they are based on this provision. Such a special provision can be made by the parliament as well as state legislature. We are having such type of directive principles of state policy. They are said to be the instrument of instructions in the governance of the country. Uh, women are provided with a series of civil, political, social, and economic and educational rights under the Constitution. For instance, equal rights as citizen, men, and adequate means of livelihood was provided under 39A. So here, whenever law to be enacted by the Parliament, they have to take into account this aspect. Now, even with respect to the equal pay for equal work for both men and women, especially, for instance, in the private sector, even today, unfortunately, there is a lot of discrimination in paying the labor. But the same is not the case with respect to labor discharged or exerted under MNREG scheme, Mahatma Gandhi Rural Employment Guarantee Scheme, like that. It is happening in the private sphere even today. So equal quantity of work is not possible. Only she can do this, that, like that. So unfortunately, this is prevailing, and only this could be altered by attitudinal change as such. So, or the structure of the society has to be altered there, or the power structure must be with them. So, even with respect to health, strength of workers, men and women, the tender age of the children are not abused, and citizens are not forced by the economic necessity to enter into avocations unsuited to their age and strength. You see, citizens are not forced by economic necessity to enter avocations unsuited to their age or strength. See, this very child labor may be one such situation, or that economic necessity of the parents might have made them to send their child for labor, or a child sexual prostitution, like that, child pornography that is unsuited to their age or strength. This is what because of the what instability in economy. Then, how to ameliorate the status of women, especially again with some more provisions of the directive principles of state policy, particularly with respect to work, education, public assistance in case of unemployment, old age, sickness, and disablement. Article 41 of the directive principles speaks about this. Law, whenever made by the state or union, they have to give importance, or even the scheme they are making, that has to be within the framework of the Constitution. So, right to work, education, or maybe public assistance in case of unemployment. But this you could see sometimes misuse. For instance, old age pension. Whenever there is children living for the old people, old aged people, they are not entitled for maintenance. But you are coming across such a situation where children are there, but the old aged people are claiming maintenance from the government. Much abuse. Even with respect to widow's pension, in the presence of the husband, she claims that she is a widow and successfully gets the widow certificate and continue to draw this widow's pension. Some of the schemes being misused or abused also. So that's why we have to take proper care in this giving of public assistance in certain areas. So state has to take steps to make conditions of work as humane and maternity relief as such made possible to the woman. So under Article 42, this provision is made. Whereas Article 43 asks the state to strive for providing living wage and a decent standard of life. So this is living wage. Say, I made a mention even today in the private sector, a lot of discrimination is taking place while considering the work exerted by men in comparison with the women. So that woman, what she is getting may not be the living wage in that sense. Living wage, that has to be conjointly used with the decent standard of life. When she has exerted such a great labor, why she should be denied of decent standard of life? So that aspect we have to consider from from this angle as such. Decent standard of life is possible only when she get the living wage. So livelihood in turn having link with the employment. So one more duty, in fact, we have imposed ourselves under Article 51A, Class E, to renounce the practices derogatory to the status of woman. This, such, here imposing a fundamental duty on every citizen, and he has to oblige to renounce the practices derogatory to the dignity of woman. Maybe what I mentioned, devadasi or temple prostitution, or offering a girl child to the god, maybe sacrificing, in other words, or child marriage in the name of god, like that. So our nude worshipping, what is taking place at maybe at Swaraba, Chandragutti, that's nude worshipping. See, this is what somewhat derogatory to the dignity of woman, practices derogatory to the dignity of woman. Now, we also have come out with that we must develop a scientific temper and humanism in our social relationship. Unless we are being rational and developing a scientific temper or humanitarian in our approach in the social relationship we are having, we could not what give the woman deserves as such. So that's why we say the vigor of the human race has to be protected, because the future of the nation depends upon them. Many judges have come out with this while upholding the special provision in favor of the women and children. So reservation for women has been incorporated by means of 73rd and 74th Constitutional Amendment in 1992, in view of Article 40, that seats is reserved for women at local level in the elected bodies, as well in rural and urban areas. So with respect to reservation of seats, in fact, Professor Ishwar Bhatt, Vice Chancellor, who inaugurated this 5-day faculty development program, very much analyzed this very decentralization led to the development. So this is a bottom-up approach that is required for development. No, the woman is relegated to the bottom position, and even in this respect, we have to make the bottom up as such. No, on their own, they have to climb. That is how the law is made it possible. Now, when the man is reluctant, the law made by men is empowering the woman or backing up from the bottom. So this 1/3 of women in the office of the chairperson is reserved exclusively for the woman as such. So even with respect to composition of wards and municipalities, there is 1/3 of the total seats has to be reserved for the woman as such. And there has to be 2 seats. I made a mention reserved for women in the cooperative sector. In every cooperative society, at least 2 women must be given due representation. This is apart from their general claim of contesting for general seats. No, that representation is required. So in view of that, this very restructure has been made possible by 1992 through this decentralization of power process. So scheme for economic development and social justice, this is very much stressed by Professor Vice Chancellor. This Article 243G empowers give authority and responsibilities to the panchayat for implementation of schemes for economic development and social justice. This has to be made use effectively by the local self-government at the panchayat raj level, as well as nagara palikas at the urban level. And we are having item number 25, with respect to the women and women and child development under the 11th schedule that I would like to call as Panchayat list. So 11th schedule of the Constitution deals with this very 29 subjects that has to be taken into account or given due preference for the very decentralization and development therein. So reservation in legislature, this is the present day problem we are coming across. Like what the reservation of seats for women being made in the local bodies, similar reservation up to 33% is expected in the union parliament as well as union council, or maybe we say Rajya Sabha. And similar is also expectation in the state legislative assemblies, and this is what having a root setback. Even though upper house or Rajya Sabha passed the bill 108 constitutional amendment bill in 2010, but the lower house or Lok Sabha never voted the bill. Now it's still pending and maybe requires the representation of the bill. The demand is that when the general seat is kept open for contesting, why such a reservation of 33 seats in the union parliament or state legislature? And this is what showing the male domination. Maybe often I used to criticize that men is more dependent than the woman, especially with respect to the emotional aspect. So he is more depending upon the woman. In that sense, woman is bringing up so as to be, he is either dependent on the mother or the wife or the daughter in the older age. So this shows that he is having more sympathetic and affection. And while making the law, all these legislation, I made the mention of British legislations and also some of the legislations enacted in the post-independent era are all having soft corner towards the woman, and that is more better. And this number of legislations are not in favor of the men. This shows other way. This very distinction between men and women is having no existence at all. So fundamental what is this very policy of protection to women is spread over various parts. I made a mention till present, and preamble mentions that, and case law as well as constitutional amendment makes such an improvement over the status of the woman. That is what we say development. So this very part 3 and part 4 provide backbone of legislation for socio-economic emancipation of women. For instance, we are having legislation related to marriage in 1955, succession 1956, Adoption and Maintenance Act also, then Minority and Guardianship Act, Immoral Trafficking Prevention Act 1956, dowry prohibition, maternity benefit, medical termination, equal remuneration, like this, the list goes on. So more than 21 legislation till date, till 2013, most of the legislations are favoring the status and improving the dignified life of the woman. So these are some of the legislative measures to provide, protect, and promote the rights of the woman we had. So in this sense, Constitution of India, I claim, is the best guarantee for the equality and social justice to everyone, particularly women who for long suffered injustice and discrimination based on a variety of customs and practices sanctified by law, religion, and authority. So, with respect to case law development, we can find such type of case laws being dealt by Supreme Court as well as state high courts. We are having that very unmarried woman dispensing her position when she got married. So this was held to be bad. That law was quashed long back in 1966. But one more case, that C.B. Muthama versus Union of India, the lone woman who fought the case for the status of woman in the Indian Foreign Service, she was denied that promotion because she is a woman. The rule was prohibiting the married woman to continue in IFS. No, IFS in this year is Indian Foreign Service. No, she was due for promotion and she was denied for being appointed as ambassador to US or some other country. So, because she planned to marry, that rule was there that she is prohibited from continuing in IFS status as such. This rule found to be discriminatory, and accordingly court has said by 1979. So it means for 29 years such rule was there. You may be surprised to find another case, Air India versus Nargish Mirza. The air hostess therein was allowed to marry after 4 years of service. But unfortunately, after marriage, the very purpose of marriage is continuation of the generation I made a mention earlier. So after marriage, after 4 years of service, she is permitted to marry by the Air India Authority. She was not allowed to carry. That is the unfortunate situation when she could marry but not allowed to carry, because there is another rule that on her first pregnancy she has to undergo compulsory retirement. No, when she was allowed to marry but not to carry, this is the unreasonable rule and irrational violation of Article 14 as well as personal liberty. Accordingly, in Air India versus Nargis Mirza, she was denied, and that very particular provision was held to be bad, unreasonable. But unfortunately, the restriction imposed upon air hostess to marry within 4 years of her entering into service is held to be non-discriminatory measure, promoting family planning as such. This is the problem we are finding here. See, she, after joining as a air hostess, she is prohibited from marrying for 4 years. So this rule was held to be non-discriminatory, and court here claims promoting family planning like that. But men was not treated like that. Men can marry the moment he got into that Air India service as such. So here somewhat irrationality can be traced. So there is some differential treatment even with respect to retirement age. This was also held to be valid as such because the service conditions were based on the agreement entered between the employer and employee. See, for the retirement age of a air hostess, the age was prescribed to 35 years. On attaining the age of 35 years, she has to undergo retirement, and on completion, she is entitled for one extension of 1 year at a time if she is found to be medically fit or physically fit by the managing director, who is neither a physician nor a doctor. This type of rule was there, and a power was given to a managing director who is neither a doctor nor a physician, and if he could find the air hostess as unfit medically or physically unfit, she can be removed from the service. And there is a blanket discretionary power. He could abuse it, and he can extend the age of retirement every time, at least for 1 year only. And again, extension requires she has to please him. This conferment of unbridled discretionary power on the managing director was considered to be bad later. So this very retirement age prescription was found to be reasonable because service conditions based on the agreement as such. Now in Andhra Pradesh, the service rule was amended, and that prescribes some 30% of the positions in each category exclusively reserved for women only. So in government of Andhra Pradesh versus Vijay Kumar decided in 1995 that the High Court, even the Supreme Court has held that is not discriminatory in nature because respect of in respect of employment or post under the state is an integral part of Article 15 Class 3, which could not be whittled down in any manner by Article 16 also. In fact, Article 16 deals with the employment, and that's why by reading 16 also, whatever the special provision made in favor of women to the extent of 30% reservation in each category of posts is not incompatible. That's what the version here. And the impact of Article 53 upon the interpretation of Article 16 Class 4 is significant in widening the policy of substantive equality to women. So this is a decision of progressive development in the sphere of gender justice. And similar is also the approach adopted by the government of Karnataka. And in view of that, what we could conclude is creating job opportunity for women was an important limb of gender equality, and it is in order to eliminate the socio-economic backwardness of women and to empower them in a manner that would bring about effective equality between the men and women, we have to go for this substantial equality. Similarly, protectionist approach was resorted by the court, especially when the woman was found to be ineligible in some employment, like jail warden in men's prison. This is what decision long back in 1972. You might have noticed in the recent newspaper, even in the combating position, the women have been recruited to army. They are also on the borders with the rifle and the guns. So this shows that women also with the modern equipment or technology can manage the prison. And in fact, the present governor of Pondicherry was in charge of the Tihar jail as an IPS officer like that. So that is the latest development. Earlier was woman was found to be ineligible in such type of employment like jail warden. So this protectionist approach, especially in bail matters, and also punishment for outraging the modesty of women, and also offences against women is always resorted by the Supreme Court. Unfortunately, for instance, outraging the modesty of women. So whenever some man does this, and he is severely punished for that. But there is no such similar offense against men. This is what somewhat can we claim that is a bias. No, there is no modesty. Often some people argue that men is not having any modesty at all. That's why there cannot be any offense against the modesty of the men. So this very stereotype approach, if adopted indefinitely, this will create a different type of role and image about the woman. So this protectionist approach always is not a better approach. This is what, in fact, often Manu was criticized that either the woman is under the protection of father or husband or the children like that. This is what continued even in the modern era. This slowly has to be modified so as to have a no bias a gender neutral approach. So elimination of this very substantial inequality is also possible being facilitative, protective, and corrective. So, but not discriminatory against them. Now, whenever laws being made that must facilitate or it must protect the interest of the woman as a group, or there might be some correction what the injustice being done. But whenever we are making it should not discriminate. So we say protective discrimination is always made equivalent to affirmative action or positive action while speaking about this article 15.4, 16.4 like that. Now we are having that Shantabai versus State of Madras, where Article 29 Class 2 was interpreted to say that did not prohibit discrimination on the account of sex in matters relating to admission to minority-run government-aided educational institutions. Such discriminations were not unconstitutional. This was the decision long back in 1954 in Shantabai versus. I doubt this is somewhat a problematic because Article 29 class 2 without this term sex is incompatible with Article 15 class 2 and contrary to equality clause, as a girl or boy can be denied admission in minority run government aided educational institution. So because this very dispensing of the term in Article 29 class 2 may result in this denial of admission. This is incompatible with concerted application of the equality provision under Article 14 to 16 of the Constitution or 15 of the Constitution, let it be. So substantive equality is also made possible that I mentioned earlier in Vijay Kumar case from Andhra Pradesh, and also maybe some initiative being taken by the court, suo moto. So suo moto steps being taken for laying down the guidelines, especially in Vishaka versus state of Rajasthan, where this very guidelines later resulted in the enactment of legislation after 15 years. So Vishaka guidelines was laid down in 1997, whereas the legislation is made possible by the time 2013. Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. See, yawning gap was created between the initiative taken by the judiciary at the apex level and also the parliament at the union level. See, when the guidelines in the absence of law being made by the Supreme Court for the prevention of sexual harassment in workplace, see, has been made possible by 2013. So guidelines continued to be the law. We are fortunate till 2013. Only by 2013, after the Union Parliament makes this law, this is operative. This is how judiciary took the initiative at the earliest. And this happened in many other cases also, right to information and also right to education. And now sexual harassment, prohibition or prevention and redressal is made possible by the parliament after 15 years of the decision by the Supreme Court. So in one more effort, mother considered to be natural guardian even during the lifetime of the father was held in Geeta Ariyaran case by 1999. Now, why I am making a mention is that if you go for the Indian Hindu Guardian and Hindu Minority and Guardianship Act, you can find that very statute dealing with this status of woman as mother that relegated the position of a woman to a secondary position. Only in the absence of the father she could be the natural guardian. That is the statutory provision as such. But Geeta Ariyaran case has made it possible even during the lifetime of the father there can be natural guardianship by the mother. That there is an exceptional circumstance also when the husband turns to be our father converts to non-Hindu religion or becomes a sannyasi or whereabouts of the father not known. In such circumstances, mother can be a natural guardian. That is there, but he may be totally not caring of the family members, then she could be considered as a natural guardian. This is what the impact of 1999 decision. So by 2013, the Supreme Court has issued guidelines for the effective implementation of the preconception and prenatal diagnostic techniques. This deals with the prohibition of sex selection, especially disclosure of the sex at the time of pregnancy was considered to be offense here, and the case has made it possible, and there was such type of decision. Then Chehra Banu versus Union of India, where triple talaq by 2013 was held to be unconstitutional, and a law was also enacted in the recent past that the pronouncing of talaq itself is an offense liable to be prosecuted and punished. So pregnant woman is also given rights under Article 21, especially with respect to life and personal liberty, and also right to terminate pregnancy. Here, the complexity arises when the fetus or unborn child is considered as a legal person and as life for its expulsion involves violation of its right to life and liberty. We are having under the traditional party to be a full person, and during the partition, a share has to be reserved in favor of the child in the womb. See, unborn child's rights are inferior to the mother's right to preserve her own health. So this is what now. This is permitted even under the MTP. Unborn child's rights are inferior to the mother's right to preserve her own health. See, up to 3 months, this is considered to be what she may not have that very right. So, the moment her right, her life is in peril, so after due consultation with the medical practitioner or a physician, our life is found to be in peril, and during that time, she may be advised to undergo MTP, medically terminated pregnancy, like that. So here in that sense, unborn child's rights are inferior to the mother's right to preserve her own health. So in view of her life, that very abortion can be carried out as such. There can be such type of liability, tortious liability for medical negligence, maybe for wrongful birth, and also there could be awarding of damages to the woman. So there can be such type of gender of the child to be taken into account. This is what important from the perspective of MTP Act 1971. But courts have restricted the operation of this right by saying that in case of married woman, consent of husband is necessary. So this is what a rider imposed by the court. Now, the only when the life of the mother is in peril, she can undergo abortion, like that. But consent of the husband or consent of the father is necessary for abortion. This is the approach adopted for interpreting MTP Act, especially with respect to abortion. So sex determination test, maybe just to know the sex of the child in the womb, are banned under the legislation. This is done to prevent inhuman feticide of the female fetus, especially. Especially, we could quote Tamil Nadu incidents of mass massacre of fetus of the girl child. Tests are permitted only for knowing the health of the mother and the child. A duty on doctor is there not to reveal the sex of the child in the womb of the mother. Some of the issues are contentious in the present day. Say, for instance, having adverse impact on women's human right in the legislative as well as judicial levels we have taken up, and Supreme Court in the recent past has clubbed some of the cases to the 7 judges bench. For instance, that may be temple entry case at Sabarimala, Muslim women's entry into mosque, or female genital mutilation, and also entry of Parsi women married to non-Parsis. And even with respect to arrest of women, there is a step of what we say, permit the police to arrest women accused without the assistance of lady police at any time, including the night hours. So, in the absence of lady police, there can be arrest of the lady accused or woman accused as such. So, there is a problem in enforcing the judicial orders. Though they are proactive sometimes, or suo moto they acted upon, the problem is that the implementation, especially we have witnessed with respect to the Shabarimala temple case, the tradition and customary practices. So, though the Supreme Court said yes, you can take the entry, but unfortunately, the strong protest by the natives or the other bhaktas of Lord Ayyappa, claiming that why the woman between age of 12 and 50, between age 12 to 50, not entitled to enter during that time only. For other days, apart from the particular days in December, they can also enter, but not during those days. and below 12 and after 50, women can enter. That is the approach, and strong protest was there by natives or even by other followers of Lord Ayappa. So one more problem we are coming across, especially in higher judiciary. So there is totally denial of position to the women judges at the apex court as well as at the high courts of various states in India. Only 3 or 4 judges at the Union Supreme Court out of some 35 men judges. And similar is the case with respect to the high courts at various states. Now, what is wrong with our mindset? What is wrong with our attitude? That's the question we have to introspect. So, anti-woman provisions have been struck down by the high courts as well as Supreme Court, and government as well as interpreted relevant provisions to the advantage of equal justice for women. Some of the new dimensions of jurisprudence have been developed by the court in favor of women could be identified in this slide, like that. Air India versus case, Mutama, Banerjee, Sagar, Sheila Barse, Saumitri Vishnu, Shobha Rani's, like that Vishaka case. See, these are some of the landmark decisions that paved the way for improvement of the status of the woman. So, as I mentioned, this lack of education, development, deficit, poverty, and lack of awareness, these are the factors we have to address. There is an urgent need to address these things as such. So, there are some affirmative actions or governmental measures being taken. Sukanna Samruddhi Yojana or Beti Bachao, Beti Padao, like that. But still, they are having their own deficiencies. So even in the personal laws area also, lot of discrimination have taken place. So this discriminatory practice have been gradually undone, and rights have been conferred upon the woman also, and special rights have been given. For instance, woman was given the additional ground of getting the divorce from her husband under the Hindu Marriage Act. And we are having a provision that husband with no means of income is entitled to claim maintenance from his earning wife, whereas he is not entitled to claim from his father. See, this is what equal status under the Hindu Marriage Act made possible. Monogamy advocated for both men and women. So husband can claim from earning wife, and wife is having additional grounds for getting additional grounds special because of her status, though claimed to be equal and egalitarian under the Hindu Marriage Act, but still she was given her special protection there for certain of the offences committed by men only, and that really strengthened her position. With respect to daughter, widow, and mother, they were given the right of inheriting the property under the Succession Act. And in the adoption, the consent of the woman is considered to be a need of the hour. Consent of wife is must for adoption of a child by the married man. But a surprising fact is married woman cannot adopt, or married woman cannot adopt. That is unnecessarily denied. And one boy, one girl child is there, they are not allowed to adopt. A boy child is there, they can adopt a girl child. A girl child is there, they can adopt a boy. Unfortunately, parents having the capacity to adopt one more boy or one more girl, or vice versa, that is not allowed under the Adoption and Maintenance Act. It is not a gender issue here between husband and wife, but it is a gender issue maybe with respect to adoption. For example, one girl they want to adopt another girl. This is not allowed. Why? One boy is there, another boy cannot be adopted. Why? This is a gender bias. So gender neutral approach is adopted in this context. And maybe this family relationship, especially be discriminatory to women in varying degrees as such, and social attitudes have been structured in such a family setting and rationalized on the basis of preconceived role of women in family and society. And apex courts seldom made some radical changes, For that, the society and family has to adopt. Adaptability is the aspect that we have to give due importance. One great problem we are coming across is so far working this Constitution of India and very particularly Article 13, Class 3, that deals with the definition of law and law in force. No judge in the Supreme Court is there enough till date to declare that personal law is also a law under Article 13, Class 2 for the purpose of fundamental rights. This is what the highlight of the entire gender justice. If the judge today of the Supreme Court decides the personal law is also a law under Article 13, Class 2, then all the legislations made under the brand of personal law, which are discriminating between men and women, will be declared unconstitutional, because unconstitutional and void ab initio from the date they being made in contravention with fundamental rights. This is the advantage. Some of your students or someone of you who may get into this judiciary and occupy the seat of the judge may be strengthened enough to take such a decision that personal law is a law under Article 13, Class 2. Similarly, various protections being given under the criminal law. All these protections can be brought under the constitutional parameter and framework, and all these legislations are held to be proper and not discriminatory in nature because of the special process only, provision possible under 15 Class 3. Such provisions are continued to be valid under the Constitution. Various executive measures are made possible. National committees have been constituted, commissions have been constituted to execute the international aspects and commitments, and in view of this, some planned agenda is required, need for some extension of legal framework for women India, expansion of legal framework is needed. Belonging to a sex is prerequisite for application of anti-discriminatory laws protection, and hence the male-female classification is both discontinuous and complementary. So there is a need of unification of personal laws, and in view of that, some pragmatic approach is required, as the law is for and we are not for the laws. So law has to be altered, amended, and only when such law being accepted by the people of this land, the law get its enforcement in the society. So this law being the pragmatic instrument really contributed for the development from what was to what is. This again could be improved because of change in attitude or creation of awareness or giving economic stability to the woman. So I express deep sense of gratitude to all the viewers and the followers, and also the other colleagues in my friends colleges, maybe this very RL Law College Davanagere, Mr. Somshekarappa and his team, and Sudha Devi at Saraswati Law College, the prime host of this very faculty development program, and her team. They are young and energetic, and along with my team here in Shivmogga on behalf of CBR National College of Law, we are also the co-host to this, and I express thanks to all the viewers and my co-hosts also. Thank you.
Thank you very much for your informative lecture as well as your marvelous sense of humor, sir. Thank you so much for sharing your time and knowledge. We will go ahead and take some time for questions now. It looks like we have some few questions. Dr. Raju Vadapalli, he have posed a question to you, sir. Can scientific temper among policy makers through constitution? I repeat, how we can improve cyber policy make constitution?
Not audible.
Could you catch it, sir?
Please repeat.
No, yes, sir. How we can scientific temper on policies through constitution?
No, Constitution has provided such a provision that we must be rational and develop scientific temper. So we must be rational in our decision making. This is possible only by being haves. By being haves means, I made a mention, having such education, having such proper education and attitudinal change commencing from private sphere. See, be the change in you, what Mahatma Gandhi has advocated, that it has to start from we the people. We only can change our attitude, we only can change our mindset towards the other sex. See, in that sense, we can have the balance of power. When we could accommodate and when we could respect the other gender or other sex, naturally there can be development of rationality in that. In turn, that will be a scientific temper. So that could be incorporated in the lawmaking business, and morality can also be taken into that. Both this scientific temper, morality to be incorporated in the making of law, and that will eradicate the gender bias.
Thank you, sir.
Fine.
One more question posed by Dr. Prama. That is, role of women is still not commendable in panchayat after winning election. For this, who is responsible? I repeat.
The problem is, I can understand. I did some work on this.
Who is still not commendable in election?
No, that's a personal approach, not commendable like that. At least we started giving representation in the panchayat, and only 25 years have gone by. By 1992 onwards, that greater representation has been given to the woman in the local self-government. What is happening is here, most of the women representatives are again backed by the men behind, either the father or the husband or the son, that they are taking care of what the external activities or the activities in the public sphere, and even the decision taken by that woman is somehow managed or influenced by the male partner behind her. So this role has to be dispensed. That is what restructuring in the family relationship is also required. Her identity is to be recognized, not simply because she is a woman that she has to be sidelined or she could not take the decision, shall not be the attitude of father or husband or the son. So she is in a position to take the decision, let it be. So she must be allowed to go out and act on her own. For that requires education. She has to be educated from that perspective. Naturally, she will do commendable job. Many of the gram panchayats dominated by women only, they are less corruptive. They are very much development oriented. So you can check such gram panchayats where the women have dominated. Though the men were allowed to contest, that women have dominated nearly 90%.
Thank you, sir. One more question from Jayasimha, Principal, BV Bellad Law College, Belgaum.
Yeah.
The question is, does the stringent law alone is sufficient to curb the gender violence?
No.
I repeat, does the stringent law alone is sufficient?
No, law is not the last resort. Law is for us. We are not for the last. Law is for law as such, maybe a pragmatic instrument to eradicate the greater evil. If that is considered to be greater evil, to that extent it can be used as a pragmatic instrument and nothing more than that. That's why I stress more upon what the attitude of the men, or the educational awareness, or the claim made by the woman herself on her own, not at the instance of somebody. No, this can be possible only by educating the girl child. And that's why government is having a wonderful scheme that till her degree education, the student exam this fees is exempted, tuition fees exempted. And if she attains that qualification, not really the general education, the awareness she must have what is going on in her vicinity. She must be made aware of that. See, because of the television, because of the online, she could expose to many things what she was not exposed to being in the home. Earlier, she was not exposed to, but now she is exposed to what's going on in neighboring state, neighboring Gram Panchayat, neighboring district, or neighboring state. Now she can take the decision. So this is how the greater change is possible. Apart from law, law is one such instrument to overcome the problem. Happy, Jessima?
Okay, thank you, sir.
Thank you.
Final.
Tell me. Okay, I'm still.
Finally,
Yeah.
we come to the end part of this second session. Now, I request Ramesh K, Assistant Professor Saraswati Chitradurga, to deliver vote of thanks.
Respected distinguished speaker, Professor Jagdish sir, respected Principal, Oral Law College, Professor M. Somsekhar sir, our beloved Principal, Professor M.S. Sudevi Madam, and other dignitaries and dear participants, good evening one and all. It is my proud privilege to propose to vote of thanks, Speaker, Professor G. on constitutional framework for gender justice and development. So, on behalf of the Saraswati Law College, Chitradurga, Inaugural Law College, Davanagere, CBR National College of Law, Shivmogga, and all the participants of this faculty development program, I would like to thank our today's speaker, Professor G.R. Jagdish sir, for giving his precious time. Thank you, sir.
Thank you all.
I thank our beloved principal, Professor M.S. Sudevi, Saraswati Law College, Chitradurga, and Professor M. Somsekhar sir, Oral Law College, Davanagere. Thank you, sir and madam. I thanks to all the faculty and lastly, all teaching staff of the Saraswati Law College, Chitradurga, Oral Law College, Davanagere, and CBR National College, Shivmogga. Thank you, one and all. Thank you.
Thank you, sir.
Thank you.
Thank you for today's National Faculty Development Program on Development. And once again, I request all the participants to the feedback form provided in the link that is in chat box of Zoom and YouTube. And finally, on behalf of Saraswati College and CBR now Shivmogga, I thank you for joining us today and have a great rest of your day. Thank you.
Thank you, sir.
Thank you. Thank you, everyone.